Welcome to the Sri Lankan Understanding, a platform on which we explore the past, present and future of Sri Lanka, an island in the Indian Ocean. We look at the potential and where this country can go in the years ahead. Our topic of conversation today is constitution making in Sri Lanka. We've invited an expert in the legal sector who is an attorney at law of the Supreme Court of Sri Lanka. He is a member of the Australian Centre for Intellectual Property in Agriculture. He's also a former advisor on legal affairs to the Education Ministry. Dr. Chamila Talagala, thank you so much for joining us on this episode.
Thank you very much, and I'm glad to be here.
If I were to go back, when we look at the legal sector, it dates back a long period of time. But up to where can we trace it, given records that we have right now, as to how constitutions evolved, how constitutions were used, up to where could we trace it?
If you take our legal system, of course, I would say we have a very rich and fertile legal system. Basically, it's a mixture of various legal systems resulting from historical antecedents. As you would know, as at now, we have basically 5 systems of law. That is Roman Dutch law as the general law, which is applicable in Sri Lanka. And then you have the English law, and you have the personal laws like Desavalami law, Muslim law and the Kandyan law. And as I have said, all these legal systems have come into the picture because of historical antecedents. Earlier, when Sri Lanka was governed by the Sinhalese kings, we had the Sinhala law, which was generally applicable to all the people. And during the same period, we had these personal laws like Desavalami law, which was made applicable to Malabar inhabitants of the Jaffna provinces. And the same Sinhalese kings applied Muslim law to the Muslim merchants who came to Sri Lanka for their business activities. And as you would know, in 1658, the Dutch came here, and they introduced Roman Dutch law in the maritime provinces which they governed. And before that, although Portuguese were there, they luckily or unluckily they didn't introduce any of their laws to Sri Lanka. And in 1796, British occupied the maritime provinces, and from that point onwards they kept on applying their English laws to matters like commercial activities and things like that. But their policy in terms of the proclamation of 1799 was to retain the existing laws in Sri Lanka.
If you go back to 1931 was an important point in our history in terms of universal franchise, in terms of constitutions, where we're going. Could you take us through 1931 and why we tend to turn to 1931 as a watershed moment?
Yes, it's a very good question which you asked, because 1931 becomes important in 2 respects. One is the Dynamo Constitution was promulgated or introduced into Sri Lanka in 1931. The second important factor of 1931 is universal adult franchise in Ceylon was introduced in the year 1931. Now, as we would know, Dynamo Constitution becomes important in various respects. Basically, I would call the Dynamo Constitution as the starting point, which I think led Sri Lanka towards a system of self-government. And it was the constitution which actually trained the local legislature or local members of the legislature to have experience about how to govern a country and how to undertake the responsibility of a government as well as responsibility of an executive. And as we very well know, during that period there were a lot of reform which happened through the executive committee system, like agricultural reforms, educational reforms, Kannangara reforms and things like that. Because of that, the Dynamo Constitution becomes important. And the other one, as I said, is the universal adult franchise. Now, before 1931, certain people in Sri Lanka were given the right to vote, the right to exercise franchise, but that was based on certain conditions like the wealth they possessed and the education they kind of gained and all that. But in 1931, what happened was those conditions were done away with, and all the people were given the right to vote. I wonder whether that was was sort of a good decision that Sri Lanka made at that point, because as you would see, this universal adult franchise contemplates a one-man, one-vote system. Now, as some people like the former Prime Minister of Singapore has said, this one-man, one-vote system is workable in a democracy where the masses are very well educated and they have the required economic means. But when it comes to the poor third world countries, you would see that masses are not educated, as well as there are economic needs which they require. So in that sense, one person, one vote would sort of create a situation where it is possible that the votes could be kind of obtained through malpractices. Like, say for example, when you provide certain economic benefits, it's possible for a vote to be obtained, like say for example a meal, a packet of rice, or a bottle of arak, or something like that. And on the other hand, when people are not educated, they can't make an informed decision. So in that sense also, it's not possible for an uneducated person to kind of exercise his vote and express his true will. So in that sense, it's a bit questionable whether the one man, one vote system which was introduced by the Donoughmore Constitution in 1937 has done much for the benefit of Sri Lanka.
That's a very valid point, and I want to take that further in terms of much criticism. Even 1931, they talked about us being a guinea pig, that the British were testing it out in a colony to see how it would work. And it so happens that Sri Lanka now claims to be the oldest democracy in this part of the world. But then you've got to understand whether we've made the necessary progress, whether we've matured as a polity at the end of the day. We want to come back to that. When we come back on the next segment of the Sri Lankan Understanding, as we continue to focus on constitution making in this country. Welcome back. We're in conversation with Dr. Chamila Talagala, and we're talking about constitution making in Sri Lanka. We talked about the past. We talked about what processes were in place, what impact there was during times of colonialism. When we come to more contemporary periods, when we come to 1972, we have the promulgation of the first Republican Constitution. But once again, there's a bit of sensitivity with regard to the promulgation process. Can you shed some light on that?
Yes. Now, normally when constitutions sort of change, there is this concept in law which we call legal continuity. What that basically means is that the subsequent constitution should derive its legitimacy or validity from the previous constitution. Now, if I were to take an example, the 1978 constitution, it derived its legitimacy or validity from the 1972 constitution. That was because in the 1972 constitution, there was the procedure which was laid down in the constitution itself with regard to amending the constitution and introducing a new constitution. So 1978 constitution was done according to that particular procedure, that is basically with the 2/3 majority of the legislature. But when it came to the 1972 constitution, the question remains whether that the legal continuity which should come from the previous constitution, that is the Salisbury Constitution, was maintained. The popular view is that the legal continuity was not maintained, which I think is quite right. That is basically because the Constitutional Assembly, which introduced the 1972 Constitution, did not derive any authority for that particular purpose from the Salisbury Constitution nor the Ceylon Independence Act. And if you look at the constitution itself, the government has specifically stated that the constitution has been promulgated by virtue of the sovereignty which is with the people. and the validity for the constitution has been gained from that particular people's sovereignty. And also on the other hand, there was this particular problem which arose after the decision in Bribery Commissioner versus Ranasinghe, which was decided by the Privy Council. There was this question as to whether certain provisions in the Salisbury Constitution could be amended even with unanimous will of all the members of the Parliament. Now, this particularly related to Article 29(2) of the Salisbury Constitution, and some interpreted the Privy Council's decision in Bribery Commissioner versus Ranasinghe's case to mean that the Salisbury Constitution, particularly Article 29(2) of that particular constitution, could not be amended even with all the votes of the members of the legislature. As a result of which, there was no possibility of amending the constitution or bringing a complete new constitution by repealing or replacing that particular Salisbury Constitution. Amending was possible as long as Article 29(2) was not infringed or violated. So I think that was the basic reason why in 1972 when the constitution was promulgated, that was justified by the government on the basis that in their election manifesto, the ruling party's election manifesto, they specifically mentioned that they would be introducing a homegrown constitution, an autonomous constitution instead of the Salisbury Constitution, and the people sort of approved it because 2/3 majority government was elected by the people. And when it comes to this autonomous or homegrown concept, of course, that 1972 constitution was basically contemplated because we needed to have an autonomous or a homegrown constitution. I would say it's a fallacy, because even the Salisbury Constitution was not a constitution which was imposed by the British on us. If you go through the history, you will identify that the first draft of the Salisbury Constitution was a homegrown document which was prepared by the Board of Ministers in Ceylon with the assistance of experts like Sir Ivor Jennings, so on and so forth. And British basically accepted all the basic principles of that draft, and ultimately what culminated as the Salisbury Constitution was basically this particular draft. So in that sense, it was a homegrown constitution.
That's where Bernard Percival Peris talks about how he was tasked by D.S. Senanayake at that time in preparing the original draft on behalf of the Board of Ministers.
Exactly.
And then that Sir Ivor Jennings contributed to that as well. When we return on the next segment of this episode, we're talking about constitution making in Sri Lanka and where we are going with that particular process on the next segment of the Sri Lankan Understanding. Welcome back. We're in conversation with Dr. Chamila Talagala, and we're talking about constitution making in Sri Lanka. Out of all the amendments that we have seen from 78 onwards, one that is still very much discussed, studied, has repercussions politically, administratively in Sri Lanka, is the 13th Amendment. Now, have we fully implemented it in its entirety, or are we still only partially through the process of implementation so many years, so many decades after we saw it coming in the 80s?
Yeah, when you take the 13th Amendment to the Constitution, actually most of the provisions in the 13th Amendment to the Constitution we haven't implemented. I would say there are 3 reasons for this. Because now, if you look at the history, the 13th Amendment was actually introduced because of a particular pact which was entered into between India and Sri Lanka. And that pact or the agreement never worked out. You can call it that it was frustrated or it was avoided. Be that as it may, it never sort of worked out. So as a result of which, there was no any sort of encouragement on the part of the government to implement the 13th Amendment, because 13th Amendment was basically introduced to the Sri Lankan Constitution in order to pacify India, and you could say even to deceit India as well. And that was basically with the objective of India performing its obligations in terms of the Indo-Sri Lanka Accord. But as we all know, India couldn't perform its obligations, so there was no necessity for Sri Lanka to sort of perform its obligations by implementing and giving effect to the 13th Amendment. But having said that, I must say this too, that whether we like it or not, the 13th Amendment is now part of our Constitution. So it is very sort of unusual for a part of the Constitution to be not implemented in a particular country, because a constitution is generally considered as the supreme law of a country or a land. So if the supreme law is not implemented, then there remains a serious question with regard to the good governance and democratic principles of that particular nation or country. And the second reason why I say the 13th Amendment was not fully implemented in Sri Lanka was because there were certain problems with regard to the legitimacy of the 13th Amendment, particularly the way in which the 13th Amendment was promulgated. Now, if you would see, when a constitution is amended, the procedure for the constitutional amendment is laid down in the 1978 Constitution, and one requirement is that the bill seeking to amend the Constitution should be placed before the Supreme Court for a determination, and there the Supreme Court can decide whether the bill should be just passed with the 2/3 majority in the Parliament, or the bill requires the will of the people at a referendum together with the 2/3 majority in the Parliament. So in the context of the 13th Amendment, if you carefully read the Supreme Court determination, there were 9 judges who were involved in the determination, and out of 9, 5 judges clearly stated that the 13th Amendment, as it was placed before the Supreme Court, clearly required a referendum to be held and the will of the people to be obtained before it was passed by the Parliament with 2/3 majority. But somehow the government sort of did some changes to the bill, but those changes were never sort of shown to the Supreme Court for their advice or opinion in terms of the Constitution. And with just those changes, the Parliament approved with 2/3 majority. But anyway, since we have this article in our Constitution, that is Article 80 sub-article 3, which specifically says that once a bill has been passed by the Parliament and the Speaker endorses on that bill that the bill has been properly passed, no court of law in Sri Lanka can question the validity of that particular thing. So because of that, true, that 13th Amendment remains the law and it is part of the Constitution, but with regard to its legitimacy and validity, still there is a question which remains.
It should have been challenged at that point before it was passed in Parliament, I guess, in
Exactly.
that interim period, to be referred to Supreme Court and passed at that, challenged at that point, but it didn't happen. So we
it
went
didn't
forward.
happen basically because the time period given for
Very
a person to challenge is very short. And the third reason why I think the 13th Amendment was not fully implemented is, if you implement the 13th Amendment fully, it's totally unworkable. I would say it's unworkable because if you go through the provisions in the 13th Amendment, you would find there are a lot of problems, inconsistencies and things like that. Particularly if you read the Sinhala provisions with the English version, there are number of conflicts and inconsistencies. So in that context, it would be a huge problem for Sri Lanka to implement the 13th Amendment, and after its implementation, I would think that the system would become unworkable.
Thank you very much, Chamila. You've brought us to a very important point. And I just want to ask you what would be termed in agreement or in disagreement with all the changes that have taken place. Questions about legitimacy, continuity, implementation. Should we bring in an amendment to remove some of the last amendments in the last 20 years? Or should we just get a new constitution? We've been talking about getting a new one. People have been talking about promising it, pledging it. It has not exactly happened. There are various constraints there. But do you think very briefly that maybe we need a new one? Or we probably need to go back to the original one?
Yeah. Let me answer your question in this way. Now, from 1948 onwards, we have had all major models of constitutions. In 1948, we had the Westminster model with a very strong and independent judiciary like the Privy Council. And in 1972, we had the Westminster model with a strong parliament and a strong executive. And the parliament was obsessed with this concept of parliamentary sovereignty. And thereafter, in 1978, we promulgated this constitution, the present constitution, which is a combination of the presidential system as well as the parliamentary system. And we have borrowed from the American Constitution, French Constitution and the British model. But still, all our constitutions haven't fared well. At the end of the day, the objectives which we contemplated from the constitutions have not been achieved. So in that situation, the question arises whether the problem lies with the constitutions or the stakeholders who operate within those constitutional setups. When I say stakeholders include those who exercise governmental power as well as those who select the people who exercise governmental power. So I would say the problem lies with the stakeholders rather than with the constitution. Say for example, if you take a simple example, if you are given all the best models of vehicles to drive, and if you are unable to still drive it properly, then the problem is with the
not
driver,
with the vehicle, it's with the driver.
With the vehicle.
Absolutely, that's a very valid point. We think of more than the constitution, those who are involved in advising on how to, if you want to amend it. I guess that's where there are so many stakeholders and people who put those stakeholders into those places. Thank you very much. Thank you so much for sharing your area of expertise with us and taking us through a very long period in covering all of these areas. We've been in conversation with Dr. Chamila Talagala. We've been talking about constitution making in Sri Lanka, where we have been in the past, how it has evolved over the years, especially from independence onwards to where we are today, and what potential we have as we go forward. Join us again in another episode of the Sri Lankan Understanding, when we look at another aspect of the island. We look at the past, we look at the present, and we look at the future.